Good evening. I'll call the meeting to order. Could we have a roll call, please, for determination of quorum?
Sarah Savilicek,
Present?
Larry Chesney,
Present.
James Barnes,
Here.
Thomas Bruce,
Here.
Francine Donchik,
Present.
Philip Haran,
Here.
Michael Lawson.
Present.
Thank you. Commissioner Chesney, would you lead us in the Pledge of Allegiance, please?
Yes, ma'am. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Edwards, could we have the ethics law announcement, please?
Commissioners are reminded that if with respect to any matter or any person coming before the commission today, you have received a gift or loan, you have a pecuniary interest, you have a commitment in a private capacity such as a family, employment, business, or similar relationship, or you provided representation or counseling before an agency to a person or entity for compensation within the last year on a matter being considered tonight, you must disclose that gift, loan, interest, commitment, or prior representation at the time the matter is being considered. And you must furthermore abstain from deliberation or voting on the matter if it is clear that the gift, loan, interest, commitment, or prior representation would materially affect the independence of judgment of a reasonable person. Commissioners are also reminded that under the Planning Commission rules, if you have had any contact outside this meeting with any persons interested in a matter coming before the commission today, you should disclose the nature of that contact at this meeting.
Thank you, Mr. Edwards. Mr. Lloyd, appeal process, please.
Most decisions rendered by the Planning Commission are appealable to the Board of County Commissioners. If you disagree with the decision of the Planning Commission and you want to appeal its action, you may do so in writing within 10 calendar days from the date that the decision being appealed is signed by the Planning Commission Chair and/or the Secretary of the Planning Commission, filed with the Secretary of the Planning Commission, and mailed to the original applicant in the proceeding being appealed in accordance with Washoe County Code. Please call the planning staff immediately at 328-6100 for information on the appeal procedure and application fee.
Thank you. We're now to item 5, general public comment. Do we have any public comment?
We do. We have Ron Bell, followed by Catherine Snedeker.
Madam Chair, members of the board, nice to see you again. Ron Bell, property owner, Sun Valley. We're here to discuss my appeal that we won, and I'm hoping to get a favorable letter to you guys back to the county commissioners, and for those that sit on the TMRPA, I especially, us in this room, we're appealing to you to be very favorable to this 5-0 decision by the county commissioners that not only agreed with Washoe County Planning Department staff that they met all the requirements of items 1 through 4, and there's no adverse defects, no response to change conditions, and everything that the planners, you folks, originally said we didn't meet these conditions. So the county commissioners agreed that we made the conditions, met all those conditions, as well as the planners from Washoe County themselves agreed that we met all those conditions clearly, or at least staff did. So we are consistent with the master plan. There's numerous times that's been discovered. And I would appreciate the slide real quick, the overhead if you may. And again, this area, as you know, it painted way too wide of a brush, and it affects not just the Sun Valley Boulevard, but numerous, up to 100 homes and lots, many vacant. Many have been there since 2010, where people can't do anything with these lots and these homes. It's just amazing. And as I mentioned before, I've built in Tahoe for 20 years, Coastal Commission. I've never seen anything like this. This was just something simple. I walked up there one day 3 years ago with some plans and all excited to put a manufactured home on lot and clean it up and get the old one off. And here we are today, 3.5 years later. So, you know, I really need everybody on board helping us out with this. And we do have a number of people out there that have been financially affected by this. And as we all know, this area is in a terrible affordable housing crunch. We don't need retail, and nobody is going to come along and build a strip mall and wipe out whole entire blocks and come in big Walmarts and cinemas like they imagined in the 90s when this master plan was done for Sun Valley. So again, I appreciate your time and just wanted to kind of open it up with that. Thank you.
Thank you.
Catherine Snedeker, followed by Derek Perkins.
For the record, my name is Catherine Snedeker. I'm a non-person, non-resident, unenfranchised, natural woman, human being. We have a problem with you people in containers. A big problem, huge problem. Code enforcement keeps coming out and telling people they can't put them on their properties. They don't have a house. Well, gee, what about the people that are going to build a house? A contractor doesn't have any problem at all going around to bare land, dropping off his little containers wherever they want with their tools in it. But a private landowner, oh, we can't have that. No, you can't have that without a house. Well, he needs the toolbox to build his house. The Supreme Court has ruled on this kind of erratic code enforcement by counties. Regulations or ordinances must have real and substantial bearing on public health, safety, and general welfare of the public. No matter how widely entertained, you people are a municipality and you think you're an authority where you can exert communal control over privately owned lands, and that is at variance with the fundamental nature of private property ownership. You don't get to come out and tell somebody they can't have a container on their private property. It's their private property, unless you have a pecuniary or a financial interest in it in some way. The owner will not be required to sacrifice his rights, substantial need for restrictions in the interest of public health, morals, or safety or welfare. It has been held that the exercise of police power under ordinance may be proper in the general sense, but may be unreasonable and confiscatory in applied to a particular property. And that's what you do all the time. It's arbitrary and capricious. You come out and cite this guy, you don't cite this guy. It's only when a regulation is arbitrary and unreasonable that due process considerations will prevent its enforceability. U.S. v. Missouri, 1976. You have to stop this arbitrary regulation of a container that doesn't cause a public health or safety problem. And if it does, then you better, subject to penalties of perjury, show how. Because if you can't show how, nobody has to obey that code. Nobody. The law is very clear. Thank you.
Thank you.
Derek Perkins.
Good evening. For the record, my name is Derek Perkins. I am not an entity. I am a living flesh and blood man. I live in Palomino Valley. And I was recently cited for having a container on my property that I'm trying to build for my family. I bought a 40-acre parcel of land, Palomino Valley, and I'm building a house on it for me and the family. I submitted permits for my well, septic, power pole, building permit, beginning May 21st of 2018. All permits were issued. Since I'm building my house, my intent to build my house is on my private property. I bought a container in purpose to use as a tool shed. That's where I store my tools to build the house. Where else am I supposed to keep them? I have nowhere else to put them. Apparently my neighbor didn't like it my tool shed and called code enforcement and made a complaint. Brian Farmer, the code enforcement officer, came to my private property and told me I have to remove it. He also told me the neighbor said it was an eyesore. We live in Palomino Valley, which is a rural area, and it needed to be a neutral color. So I spent the extra money and I painted it a neutral color to appease the neighbor. They made another complaint that it's still there. It's told to remove it. Why didn't he check for permits? I have permits to build the house. I've got all the permits for everything. I've paid all my taxes. I've done what I'm supposed to do. Why can't I have a tool shed on my property to build my house? Got a warning telling me to remove it by August 21st, or I'm gonna receive $100 a day fine and be automatically extorted from me, and they're gonna lien my property. How in the world does that work? How are they gonna lien my property for storing my tools to build my house? Just like any construction company, I need my tool shed on site. It's arbitrary and unreasonable to make me remove it unless you can prove, subject to penalty of perjury, I'm causing a health, safety, or welfare problem to the public at large, or that the county can assert some communal control over private property-owned lands. I think it's very unreasonable what's happening here. I'm doing the best I can, obeying the laws, paying for my permits, paying my taxes, doing the best for my family. Why can't I have a toolbox on my property? In a rural area. I'm not in a subdivision. What's the problem? That's all I got. Thank you.
Thank you.
No further public comment.
Thank you. We're on to item 6, approval of the agenda.
Madam Chair, I make a motion to approve the agenda.
Second.
It's been moved by Commissioner Donchak and seconded by Commissioner Chesney. All in favor? Aye. Thank you. Item 7, possible action to approve the July 3rd, 2018 draft minutes.
Madam Chair, I make a motion to approve the July 3rd, 2018 draft minutes.
Second.
It's been moved by Commissioner Donchak and seconded by Commissioner Chesney. All in favor?
Aye.
Motion carries. We're now to public hearings. Staff, if you will read into the record the agenda item, please, and the general nature of the proceedings.
Okay. This was an item that was continued from last month's meeting. This is a request for a report on Master Plan Amendment, case number WMPA 18-0001, the Sun Valley Area Plan, for possible action, hearing, and discussion to report back to the Board of County Commissioners on the amendment to the Washoe County Master Plan, Volume 2, Sun Valley Area Plan, Policy SUN.1.2, to remove the sentence, "New single-family detached residential, including mobile homes, will not be allowed within the DCMA." The Planning Commission voted to deny the amendment at its April 3rd, 2018 meeting, and the BCC overturned that denial at the May 22nd, 2018 BCC meeting. If approved and subsequently found in conformance with the Truckee Meadows Regional Plan by the regional planning authorities, the Sun Valley Area Plan would no longer prohibit new single-family detached residential units in the Sun Valley DCMA. And here to present this report is Senior Planner Roger Pelham.
Okay, disclosure by commissioners, either ethics or ex parte communications? Seeing none, I'll open the public hearing. Mr. Pelham.
Good evening, Madam Chair. Thank you very much. For the record, Roger Pelham with Planning and Building. I do not have a presentation for you this evening. You have heard this previously. The description itself sort of says what happened. The denial by this board, commission rather, I'm sorry, was appealed to the Board of County Commissioners. They did vote in favor of the amendment, and process now requires that we come back to you sort of as keepers of the Master Plan and Development Code and ask for a report back to the Board of County Commissioners. I know that there are folks that will speak to this under public comment, but I was hoping to be available to address any questions you might have prior to that.
Commissioners, any questions of staff? Thank you.
Thank you.
any public comment on this item?
Yes. We have Christina Dombavari, followed by Jim Clip.
I am here to
I
support.
need you to speak directly into the microphone and identify yourself, please, for the
Christina
record.
Dombovari here in support of the proposed change. I am a local real estate broker and investor. I do not own such property, have no interest. However, I talk to a lot of people on a daily basis who live in Sun Valley and are very, very adversely affected by this restriction. As we know, Sun Valley is not the wealthiest part of town. Most of these people, this is the only asset that they have, and once they have an old mobile home on it that cannot be remodeled anymore, needs to be replaced, they are facing their property's value destroyed by the restriction of not being able to put a new home. Consequence of this is a lot of us have been driving up and down on those streets, know the blight. It is really not a good reflection on our community. We also have an issue with affordable housing, and this is just a great hindrance. I think it would be very wise to reconsider their existing restriction and enable those property owners, given their property rights back fully to do and improve the community, improve their land. Thank you.
Thank you.
Jim Clip, followed by Steve Hendricks.
Projector, please. Jim Clip, Washoe County resident, concerned citizen. This is about affordable housing. We all know that we have a huge affordable housing problem in Washoe County, in the state, and in the country. And this master plan basically goes against that. The master plan wants more commercial in Sun Valley. This is some of the commercial that's in Sun Valley right now. Is that really what we want to see? They say that there's no commercial available. These have been available since the building was built, which I believe was right around the time that this master plan was put together. I don't have the exact date, but there is available commercial. Here's another one. Available commercial. There is a lot of available commercial right now. Now they want to get rid of a neighborhood like this that is actually a block off the main road and make it available for commercial. Does that really make sense? Instead, this moratorium causes people to not be able to do anything with their property. And then you end up with properties looking like this. Now, I'm not saying that they're all going to be corrected, but those that are capable and able and willing will be correcting. Or maybe we'll just end up with Sun Valley looking like this. Now, as Christina just mentioned, we don't really want that, right? I don't think any of us want that, whether you live in Sun Valley or you drive through Sun Valley. We want to do our best to promote Sun Valley and help the residents of Sun Valley and everyone that has the opportunity or has to drive through Sun Valley to get to their property. They don't want to look at this right along the highway, but that's exactly what this moratorium is causing. Once again, affordable housing, huge problem right now. If we make a slight adjustment, and once again, when we adjust this master plan, we don't have to completely rewrite it. Just remove that sentence, as we talked about previously in previous meetings, or some adjustment. I'm not exactly sure the fix, but we need to come up with a fix in order to make this happen. What about more commercial? What about that Scolari's out there? Have any of you driven by that Scolari's lately? Is it still open? I think it is, but I'm not sure how much longer it's going to be open.
This master plan was a great idea. However, it was just way, way too aggressive for what's going on in Sun Valley. So please, join us in correcting this situation and making more affordable housing while improving the appeal of Sun Valley. Fellow commissioners.
Thank you.
Steve Hendricks, followed by Pamela Pappas.
Good evening. My name is Steve Hendricks. I'm a residential designer in the state of Nevada. And first, let me say that by changing this master plan, I'm not here to promote my business. I'm busy enough as it is. I don't need any more work, but Ron got a hold of me when he first purchased this property about 3.5 years ago, and we worked up a conceptual site plan to determine what he was going to be able to do with it. And you know the story from Ron that's happened since then. I'm on board with basically the same thing on the housing issue. It's not only affordable, but we're in need of more housing in the area with all the new business and all the new people that are coming to this area. And I get calls daily almost with people asking me, why is it so expensive to build? Why is it so expensive to get something designed and permitted and gone vertical so that somebody has a place to live? And there's a lot of people out there that are very in favor of making it easier to just put a new modular home on the property, which is the best way to expedite the whole situation. It's less expensive to put a unit like that up than it is to do a stick-built home. And it seems like with the need for the housing that we do need, it would be a big benefit if this part of the master plan was changed to accommodate that. And like Jim said, do we really need more commercial out there? I mean, there's a lot of commercial everywhere that's empty. And I'm sure it's going to get filled up, but I think right now the real need is for more housing and an easier, quicker, less expensive way to get that housing in place. Thank you.
Thank you.
Pamela Pappas, followed by Ron Bell.
Hi, I'm Pam Pappas. I don't really know what else I can say except to reiterate what everyone else has said. It seems like we say it over and over and over. The facts are just the facts. You know, I manage for a property owner for a small mobile home park on Sun Valley Boulevard. It's not a blight. I keep it pretty maintained. It's a little over a 2-acre area. There's a total of 12 lots in there. 10 of them have mobiles on them. 2 don't because we can't put anything on them, although they have utilities and everything. You know, so over a decade, it's been quite a loss for the property owner, you know, money-wise. And also, I have people wanting to move mobiles in there all the time now that people are starting to move mobiles again, and they can't. So I think it comes down to property rights, the need for housing, and the fact that if this commercial big plan hasn't been done in a decade, what else can I say? So I just really want to reiterate what everybody said, and please take that sentence out of the zoning portion. Thank you.
Thank you.
Ron Bell, followed by William Eccles.
This guy's starting to push me off.
Madam Chair and Board, this is just, I'm just going to go through a few examples of properties affected by this. These are vacant lots with utilities ready to go, and they've been sitting since, a lot of them been sitting since 2010. Typically, there's illegal, vehicles parked on them. A lot of times people just encroach on them. Perfect example right now, speaking of being fined, the code enforcement officer wants to fine me for somebody that put an abandoned trailer on my lot, and I think it's the 3rd or 4th abandoned trailer I've had. Perfect example here, another lot, close to the school, utilities in, ready to go, beached. I believe this is Pam's trailer park you mentioned. Is this it? So in any event, there's a whole entire block, mailboxes and everything, utilities ready to go that are affected by this as well. Here's another one. There's the utilities there. They moved a trailer off and it sits. This is one of the better ones without a trailer or something on it. Now here's an interesting one. This one's all ready to go. It's got decks, it's got stairways and everything. It just sits. This is more like your classic right here. I didn't quite get a picture of the graffiti, but of course there's some obscene graffiti on there. And again, nice, level, buildable lot. Manufactured home mover's dream, and it just sits. More lots, utilities on, sitting. This is one out right up there near the park there. Utilities in, mailbox in, ready to go, in a residential area, beach. Here's an example of a lot that would have all the utilities just sitting right there, ready to be hooked up. So you've seen this picture before. This is my lot. That's my mailbox. See how far I am from the boulevard? You can't even see the boulevard out there. And again, all utilities. I can move a manufactured home in there tomorrow. And you can see again, you probably remember this from last time. I'm a block away from the Sun Valley Boulevard at least. There's an aerial of it right here. So there's my lot out there. You see the area that's affected. I mean, you guys pretty much know that from the maps that Roger and Trevor presented. Did anybody have any questions from anybody like myself that's a property owner that affected it, or anything you don't understand about giving us our property rights back, or at least being in favor and giving us a favorable letter to the commissioners and being kind to us at the TMRPA? Did anybody have any questions? Thank you.
Thank you.
William Eccles.
Good evening. My name is William Eccles, and I own a 1/6 acre parcel just off of Sun Valley Boulevard. To make this viable for commercial, to put in a commercial building, I would have to put in a driveway. I would have to provide for parking and handicap parking and put in a handicap sidewalk. If I did all of this, there'd be hardly any room left for a commercial building. And on a lot this size, the only feasible use of it is for a mobile home. And that's what I'm shooting for. Thank you very much.
Thank you.
No further public comment.
Thank you. Close the public hearing and bring it back to the board. I'll remind the board and the public that this item was a 4-3 decision for denial by this commission, and it was appealed to the BCC with a 5-0 decision to overturn. And now we are being asked to provide the acceptance of the staff report, and then it will be forwarded on to regional.
Madam Chair,
Yes, Commissioner Ryan.
I think that, this board, commission heard the application and rendered a decision as we individually saw fit at the time. I understand that the county commissioners saw it another way. I'm very happy to accept their decision and move on.
Madam Chair,
Commissioner Chesney.
I'd like to make a motion.
Thank you, Mr. Chesney.
I move that the Washoe County Planning Commission acknowledge the action of the Board of County Commissioners to approve Master Plan Amendment Case Number WMPA 18-0001 that will allow single-family residential uses, including mobile homes and manufactured homes, within the Sun Valley Downtown Character Management Area, subject to the approval of the special use permit, and directs the staff report to report back to the Board of County Commissioners without comment.
I second that motion.
Okay, it's been moved by Commissioner Chesney and seconded by Commissioner Donchak. Any discussion on this item? I do have some points that I would like to make, and this is to the audience and to my fellow commissioners. 3 of us on this board do sit on Regional Planning Commission. We will hear this item at Regional, but for the public or any of our colleagues here to ask for our decision or how we would vote at Regional is not appropriate, because that can be considered ex parte and could eliminate our opportunity to have our input into that vote at Regional. Any other discussion? All those in favor of the motion signify by saying aye.
Aye.
Opposed?
Nay.
Motion carries 6-1. Let the record reflect that Commissioner Bruce voted no. Thank you. We're now on to item B. Mr. Lloyd?
This is abandonment case number WAB 18-0004, the Lupin Drive abandonment, for possible action, hearing, and discussion to approve an abandonment of Washoe County's interest in roughly 77,000 square feet of right-of-way of unimproved roadway on Lupin Drive between East 4th Avenue and East Gepford Parkway. If approved, the property will be abandoned to the abutting property owners. Also, if approved, the eastern half of the designated eastern half will be designated as common open area in connection with the Valley Vista subdivision that was approved on April 3, 2018, immediately to the east of the roadway proposed for abandonment. And the western half of the roadway may also become common open area in the same subdivision if the abutting property owners on the west side do not accept the abandoned area. And here to represent Washoe County, Julie Olander.
Thank you. Any disclosures by commissioners, either ex parte or ethics? Seeing none, we'll open the, I'm sorry?
Just going to say I drove by.
Okay, thank you. Open the public hearing. Thank you.
Good evening, Commissioners, and this is Julie Olander with Planning and Building. So this is an application for an abandonment of public right-of-way on Lupin Drive. This area is between East 4th Avenue and East Gepford Parkway. It is an unimproved area, has not been paved. The abandonment is for 77,484 square feet of right-of-way. The parcels to the west are zoned medium-density suburban, and to the east is high-density suburban. Here's a view looking north from the site, or at the on the roadway, the right-of-way. And here is looking south. So you can see it's very undeveloped, fairly overgrown. The abandonment request is from a condition from the tentative map for Valley Vista that was approved by you by the Planning Commission on April 3rd of this year. The condition read, the applicant shall apply for an abandonment of Lupin Drive right-of-way adjacent to the site prior to the recordation of the first final map. So that's why we are before you today, is that applicant has come back in for this abandonment. We did look at the completing Lupin Drive during the tentative map process. It was concluded that the existing roads service the area satisfactory. Also, at that intersection of Lupin and East 4th, it is in the 100-year FEMA 100-year flood area, and to improve that intersection would be extremely costly. And the applicant for the Valley Vista it would have been very expensive for them, and as if you might remember, that was an affordable, that was proposed to be an affordable housing project. 4 of the 10 reviewing agencies did provide comments, and there are 2 departments provided conditions. The abutting property owners were noticed. There was legal notice in the Reno Gazette-Journal. Abandonments do not go to the cab. I did receive 1 phone call, and she basically asked for explanation and was overall for the project because she lives adjacent to the right-of-way and gets a lot of traffic of our ATVs and bikes and stuff like that that kick up a lot of dust, she said. But I didn't receive any other calls or comments. NRS does provide for the Planning Commission to vacate the easement. Staff has concluded that the adjacent parcels will not be negatively affected and that the surrounding properties can continue to have the same access to their properties. These are the 3 findings, and I was able to make those findings, and that's listed in my staff report on page 9. And here's a possible motion, and I'm available for questions, and the applicant is also here.
Do we have questions of staff?
I have a question.
Commissioner Bruce?
You say that they were noticed. Is my understanding that there were only 2 or 3 on the the west side of that property that were there? I may be off, but how many are there?
So for an abandonment, you're required to notice adjacent parcels. I noticed everybody on Melinda, the people off of Gedford. I believe the map is provided in your staff report, and the properties to the 4th. So it's just the adjoining parcels that you need to notice. I expanded a little bit because I felt like there might be some people off of the other part of Lupin that might be impacted. The woman that did call me is not quite on this map. She's on just north of the property that's on the corner of northeast Lupin and 4th. So I noticed a little bit up Lupin, and like I said, the noticing map is in your staff report.
I was just wondering how many were adjacent to the unimproved Lupin on the west side of that. How many parcels?
So on the west side, you have the large parcel that's down to the south towards Getford. That's 1 property owner. And then all the properties that are off Melinda are owned by the same property owner. There's only 1 property owner for all those parcels.
So does that mean that the property owner for the Melinda property also owns the large parcel, or is there just,
No,
or there
I'm
2?
sorry. There are 2 different property owners,
Okay.
excuse me.
Have they been contacted directly? I mean, since there are only 2, I understand about noticing, but there are only 2 there.
So the requirement is for mailing. I didn't personally call them, if that's what you're asking. The notice was sent to them directly. It was not returned. So my assumption is that they received them. The applicant will have to contact those property owners to complete the abandonment. They have to be asked if they want, it's a 60-foot wide abandonment of the roadway, so they could get 30 feet of it on the east side and then 30 feet on the west side. So if the people on the east side, on the west side choose not to take that portion of the abandoned right-of-way, then it will go to the property owner to the east. So they will be contacted by the applicant before the abandonment is recorded. That has to happen to make sure that to give them the option to take the 30 feet of right-of-way or not.
Thank you.
Any other questions for staff? Do we have an applicant presentation?
For the record, Dave Snellgrove, Planning and Right-of-Way Manager with CFA, here representing the applicant on this project. Won't go through the presentation unless you want me to go through the presentation. We're in agreement with the staff's review and their ability to make the legal findings, and we are in agreement with the conditions as presented. One thing I will point out that, to clarify, we're required to contact the adjacent property owners, of which there's 2 different property owners. The north 6 parcels on the west side are all owned by the same, I think it's Belinda No. 1 LLC is the name of the owner. And
If they will have first right of refusal for the western 30 feet. If they don't want the western 30 feet added into their property, then a full 60 feet would go into the Valley Vista project. It is a requirement on the Valley Vista project that any areas that are abandoned to the Valley Vista project remain in open space common area. I'm available for any questions you may have.
Commissioner Bruce?
Have you made any attempt to directly contact the two property owners?
I have not sent anything out yet.
If I may, Mr. Edwards, would you talk to the commission about how this noticing occurs and what the timeline is for noticing of adjacent property owners, please?
The exact method is not specified. It says the method shall be in a manner that does not require a signature from the person receiving the notice, but does confirm delivery of it. And it has to be 10 days before the hearing. And it's those abutting or connected to the area that's to be abandoned in this case. So there's a noticing map that's been provided. And that's the extent of the information that I have on the legal end of this. But that's the standard that applies.
For noticing.
In the case, yeah. To get personal contact or a phone call or those kind of things they're not required. There's nothing that prohibits it, and I'll say that, but there's no requirement that it be done.
Thank you. Commissioner Bruce?
Clarification, I may have misunderstood, but I thought you said that the notice required like a signature that they had received it. Like,
No.
No. Okay. Okay. I misunderstood.
Okay. Other questions for the applicant? Okay. Do we have any public comment on this?
We do not.
Okay, I will close public hearing and bring it back to the board.
Madam Chair, I want to make a
Commissioner
motion.
Donchak?
I move that after giving reasoned consideration to the information contained in the staff report and information received during the public hearing, the Washoe County Planning Commission approve, with the condition included as Exhibit A to this matter, abandonment case number WAB 18-0004 for Land Bank Development Company, LLC, having made all three findings in accordance with Washoe County Code Section 110.806.20.
Commissioner Chesney, second.
Okay, it's been moved by Commissioner Donchak and seconded by Commissioner Chesney. Is there any further discussion? All those in favor signify by saying aye.
Aye.
Opposed? Motion carries unanimously. Thank you. We're on to item C, 8C. Mr. Lloyd?
This is amendment of conditions, case number WAC 18-0001 for Falcon Ridge for possible action, hearing, and discussion to approve an amendment to condition of approval number 1E of approved tentative subdivision map, case number TM 14-003 for Falcon Ridge. Condition 1E requires substantial compliance with plans and documents submitted. The amendment would allow the reservation of 2 parcels of land as remainder rather than common area, which would allow for the potential development of those parcels as a residential subdivision or other type of development at a later date. And here to present this again is Senior Planner Roger Pelham.
Thank you. Any disclosures by commissioners, either ethics or ex parte?
I drove by.
Thank you. So I'll open the public hearing and staff presentation.
Good evening again, Madam Chair, members of the commission. Again, Roger Pelham with Planning and Building. This is a very simple request. The Falcon Ridge subdivision is located, as shown here in the vicinity map, at sort of the south end of Sun Valley. This is within a specific plan that allows 10.6 dwelling units to the acre. There are 2 parcels shown on the tentative map as being common area. Those would like to be, the applicant would like those to be remainder rather than common area, so they can be developed in the future. And really the main question is, if these 2 parcels of land are removed from the subdivision, is there still sufficient density for the number of dwellings that are approved on there? And the answer to that is yes. So even if this about 6 or so acres is removed, the remaining land is still actually, the number of dwelling units approved there is still less than could conceivably be approved. One thing about this has been graded and retaining walls built and utilities have been installed for a very long time. This has been sitting sort of fallow, unbuilt for a number of years. At some point in the future, those 6 or so acres that would be removed could theoretically have 67 dwelling units developed at some point in the future. That's going to be difficult because there's a big drainage way in between sort of the two areas of the subdivision. So it won't be simple, but at least in this case it is possible. So the arrows here show the two areas that are proposed to be changed from common area to remainder. You can see the approved tentative map there. Notice was sent to 66 affected property owners. The Sun Valley CAB didn't meet during this time period, but I did provide it to them. I did not receive any comments back from any of those members. This was provided to all of the appropriate reviewing agencies. I did not receive any recommendations for denial nor any recommendations to change any of the other conditions. The findings and my comments on them are listed on pages 8 and 9 of your staff report. I can address any of those specifically if you'd like, but otherwise I would like to recommend approval with conditions, and I have provided the motion on the overhead here and again in your staff report. With that, any questions that you might have, I'm available.
Any questions for commissioners for staff?
Madam Chair, may I?
Commissioner Lawson, absolutely.
Roger, you mentioned that this has been semi-developed for a while, but has been sitting undeveloped because obviously it was zoned for a common area. I'm just curious about why all of a sudden this is in front of us without the time period for CAB review. So the timing is kind of suspicious to me. Can you help me understand how that happened?
Certainly, and first let me back up a little bit. I may have misspoken. This has been developed in terms of the grading, the retaining walls, the infrastructure, all of those things are in place. None of the dwellings have been built, okay? The reason the CAB didn't hear this is there's nothing nefarious. They simply meet on a particular schedule. This one fell off cycle. But in that case, again, we provide that application to each of the members of the Citizen Advisory Board, asking for individual comments. None of them chose to provide comments.
Thank you, Roger.
Certainly.
Other questions from commissioners? Commissioner Hurd.
When was the first phase, or whatever you want to call it, first started, I guess?
I'm actually going to refer to the planning manager on that one. This was actually his case back then when the initial dirt work was done with the...
This property has, or this development has gone through numerous iterations, starting back in around 2000, maybe earlier. I know for this particular development was started, and the construction began around 2004 or 2005, I believe. And it was a victim of, like many other developments, of that recession that followed soon after, and that's the reason it was never completed. But shortly after, I believe there was a request by the applicants to eliminate that map, because keep in mind, these lots were actually recorded at one time, and then it was reverted back to acreage. They came back and asked for an intensification of this property, and that fell through, and so they came back again in 2014 for the tentative map that is currently approved for 142 lots, which is what's on the site now. That's basically a summary or a history of that property.
Thank you.
Any other questions of staff? I assume we do not have an applicant presentation. We do have I'm sorry. I am so sorry. You're sitting there right there. Okay.
Good evening. Derek Wilson with Rubicon Design Group on behalf of the applicant. I think Roger gave a complete explanation. I would just like to briefly add that this area was always intended for development. The Sun Valley Area Plan shows as much. It contains an exhibit that shows this area containing residences. And if the overhead is working, I could show that. That's a site plan that was part of a specific plan that was filed with the county. That specific plan was subsequently absorbed into the Sun Valley Area Plan. And that's primarily due because the long history of this property. It's been waiting a long time for development. So that document was, that specific plan becomes part of the zoning code, and it was adopted into the area plan. So this area to the north is what we're talking about. And obviously here it was meant to contain buildings. So to be fully frank about this, that labeling of common area was sloppy labeling on the part of some of the previous exhibits that were done on this property. It should have been identified as future project area or future phase. So it's not that we're coming back and asking for more or to get rid of what was always meant to be open space. This was meant for development. So it's in effect a cleanup of the current mapping. So that's the only addition I wanted to make. I can elaborate if people request it. Thank you.
Commissioner Chesney.
Yeah, so currently it's common area, not open space, right?
Yes.
Gotcha. Okay,
Right.
thank you.
Other questions for applicant?
And there is development in play. There are retaining walls and there's graded flat.
Yeah,
Yeah, we
It's
can
ready
see
for
all that,
development.
yes.
Yeah.
Do we have public comment on this item?
We do. We have Carmen Ortiz.
Hi, Carmen Ortiz, Sun Valley Cab Chair. So I did receive a phone call from a concerned cab member who lives over in that area, and her concern is with Hug High School being moved right over there at Well Creek, that's going to produce more traffic and safety issues. So I wanted to be sure and bring her concern forward. Thank you.
Thank you very much.
No further public comment.
Okay, I'll close the public comment and public comments and bring it back to the board. Further questions or entertain a motion?
Madam Chair,
Commissioner
I'd
Chesney.
like to make a motion.
Certainly.
I move that after giving reasoned consideration to the information contained in the staff report and the information received during the public hearing, Washoe County Planning Commission approve amendment condition case number WAC 18-001 to tentative subdivision map case number TM 14-003 Falcon Ridge for Falcon Ridge by Desert Wind LP, having made all the 10 findings in accordance with Washoe County Section 110-608.25.
Madam Chair, I second.
It's been moved by Commissioner Chesney and seconded by Commissioner Donchak. Any discussion? All those in favor signify by saying aye.
Aye.
All those opposed? Motion carries unanimously. Thank you. We're now on to item 8D.
This is Master Plan Amendment Case Number WMPA 180005 and Regulatory Zone Amendment Case Number WRZA 180005, Mario Road for possible action, hearing, and discussion to approve a master plan amendment to adjust the boundaries of the existing rural residential and suburban residential master plan designations on the subject property by swapping the designations applicable to the two portions of the property, and to approve a regulatory zone amendment that would similarly swap the current zoning designation on portions of the property by changing .49 acres of property from low-density suburban to high-density rural, and by changing .49 acres of property from high-density rural to low-density suburban. And here to present for planning and building is Staff Planner Chris Bronzik.
Thank you. Any disclosures by commissioners, either ethics or ex parte? Seeing none, thank you.
Thank you. So, as mentioned, we are looking at WMPA 18-5 and WRZA 18-5 master plan amendment and regulatory zone amendment for 3 properties off of Mario Road. What the applicant has proposed is roughly swapping a half acre of existing regulatory zone and master plan categories with a separate half acre of existing designations. The master plan category being swapped is rural residential, and they're swapping it with suburban residential. The regulatory zone being swapped is low-density suburban, and they're swapping it for high-density rural. The intent of this is not to increase allowed lots or homes or even intensify the use. The primary benefit of this is to allow for a singular access through the center of that property. So these 3 properties are located off of Mario Road, directly south of Tumwa Channel and south of Interstate 80. I've provided a master plan category map which depicts what they are changing. So as you can see, the rural residential on the left is the existing map. And so they're moving the northern portion, that rural residential, to the south and doing a direct swap. One thing to note about that southern area is there's considerable slopes there. That is currently zoned GR. This is not, would be untouched. But there's 15 to 30% slopes there. So that area could not be developed. The amount of land that's being adjusted, total is 11.4 acres. The regulatory zone map, again, to the left is the existing, and they're taking the northern portion of the HDR and moving it to the southern. Per the Washoe County Master Plan compatibility land matrix, high-density rural has a high compatibility with low-density suburban, and again, I've already touched up on that centralized roadway. For the regulatory zones, LDS, low-density suburban, does allow for 1 dwelling unit per acre, and high-density rural allows for 1 dwelling unit per 2.5 acres. What has been proposed here is simply the amendment, but they did supply a proposed site layout. And the site layout that they did provide does replicate existing patterns of growth within this area historically. So this is the site layout. Unfortunately, this site layout is quite busy. They chose to add everything. I believe the applicant has cleaned it up a little to be able to give you a better understanding of what they're proposing. This plan was provided to the, presented to the Citizens Advisory Board on June 18th. There was considerable discussion regarding the layout, the noticing, and further staff review of this plan. And there was also considerable concern from a couple of members of the public on whether this was an actual attempt to increase density. Through the analysis, staff did not recognize that. So I provided a notice map. So 32 individual property owners were noticed within 900 feet. However, there was a total of 35 entities noticed. And with this, staff does recommend approval for both applications, and potential motions are within the staff report.
Is there questions of staff before the applicant presentation? Okay. Is there an applicant presentation? See, your name appears on this. The other one, it did not, so.
Thank you. Derek Wilson with Rubicon Design Group on behalf of the applicant. Thank you. I'll try not to repeat what Chris just went over, but I have to recognize this is kind of an odd request, and it's such a small area. But that red boundary is essentially the project area. So what we're trying to do is rationalize the zoning boundaries. You can see the parcel lines are irregular in this area, and consequently the zoning is also even a bit more irregular than the property lines. So in technical terms, it's just we're swapping one bit of SR for one bit of RR in the master plan, and then similar swap with the zoning. So we're not bringing any new master plan or zoning categories to the area. We're just moving the boundaries of what's already there. And again, this is technically what's happening. We're kind of straightening, I guess you could say, that SR boundary in the master plan. And then in the zoning, same kind of thing. We're moving a pink area north and an orange area south. I hope that's clear. I could explain that for hours if people really want to hear it, but that's what we're doing. So I agree this exhibit is awful, and I have to apologize. Engineers love more details better for regular people, not always. If we could switch to the overhead, I have a slightly improved version of this. There we go. So on this one, I tried to draw some detail, and I labeled the lots. It's 11 lots. So we're allowed 11 lots now, and with this change, we'd be allowed 11 lots. But what this swap really does is it allows us to have that central roadway that serves the majority of the lots, and we have more uniform lot shapes. We avoided flag lots. We have more predictable utility layouts and more predictable driveways. So the houses are oriented towards the street. The driveways are regular. We only have that one new intersection on Mario Road, and then, well, I think it's still Mario Road over here. This road continues off the paper out to here, so it continues all the way through. So we have good emergency access, good predictable roadway. Without this change, we ended up with kind of a cluster of lots over here that had driveways out on the Mario Road. We had some confusing utility layouts. It just wasn't a very satisfying layout, and houses were kind of facing each other. It just wasn't very appealing. It was a very non-standard kind of contorted layout. So I feel like this simple zoning swap allows a more standard suburban style layout. So that's really all I have. I can elaborate if people have questions. Thank you.
Questions for the applicant? Commissioner Bruce?
I have one, and I'm trying to understand the case description where it says low-density suburban is one dwelling per 1 acre, and it says high-density residential, but you've been talking about high-density rural. I assume that's a misprint. It says max density 1 dwelling per 2.5 acres, and I don't see how you can get 11 units if you have any that require 2.5 acres out of 11 acres. So, I mean, can somebody clarify that and explain either what is wrong with this statement that says there apparently is some high-density rural at 1 per 2.5 acres in the current zoning, and there is some low-density suburban at 1 dwelling per 1 acre, and there's only 11.3638 acres, pardon me.
If we could have staff address that, please.
All right, I apologize for that. So there was a misprint with the regulatory zone. My understanding, based off of discussions with the applicant, was that there was a potential for this to be a common open space. I don't want to speak fully for that, but I think at this point I might ask Trevor to take over on this one.
Okay. Mr. Lloyd?
Thank you. And I apologize, I haven't done the calculation myself, but I would ask the applicant if they can come back and maybe provide some clarification. This is the first that I've seen of this graphic, and I'm not sure that Mr. Bronzik has seen it either, but it does show 11 lots, but I don't know what the actual breakdown is of the acreages of the LDS versus the HDR. Maybe the applicant can, through the chair,
Yeah.
permission, can provide a little bit of clarity on that regard.
I hope I can. I have done those calculations leading up to this point. I don't have them fresh in my head, but we had that LDS. I wish I had the LDS total in my head, but that gives us 1 unit per acre. I'm sorry, I would need to go look at the acreage totals per zoning category, but we ran this. In fact, Hunter Creek Engineering ran that analysis, and they were satisfied that it fit. I could say that if we didn't qualify, if we made a mistake and we don't qualify, we don't qualify, and we would revise our unit count down. I think the overall point is that we'll adhere to the existing zoning maximums. We won't be attempting to bring increased density beyond the current zoning categories that are in place now.
Could you put up my presentation again so I can pull up one of the graphics? So on page 9 of the staff report, in the background and current conditions, there is a breakdown of the current zoning. Just one of the pictures of the maps.
Okay, if I can just jump in really quickly. There may or may not be an exact calculation provided by the applicant, but through a process, whether it's a parcel map or a subdivision map, staff will very clearly determine whether or not there's adequate density through the zoning on the properties to allow for whatever that unit count will ultimately be. And so I don't know if that map that was provided by the applicant is accurate or not, but at this point, that's not, the request is to change 0.49 acres of one designation to 0.49 acres of another.
And if I may, Mr. Lloyd, with references on page 9, it does give us the breakdown of acreages with no increase in density. Is that, okay. Anything else you would like to add? I'm asking staff, just one moment, Commissioner Bruce.
If you'd like me to go over it for the record, I can.
Please do.
So I'm going to be flipping between the two, and I apologize.
That's
for
fine.
that. So the large lot to the east is 4.7 acres. The breakdown is 82% low density and 18% general rural. That is current. So unfortunately, this analysis does not break down what it would be at the beginning with the change. This top property is 2.16 acres, and we're looking at 98% high-density rural and 2% low-density rural, or low-density suburban. I apologize. And then this property my understanding is it's primarily high-density rural. This part is not broken down in the background and analysis. This is 4.5 acres. That little corner is general rural, though.
Commissioner Bruce.
How many acres result in high-density rural total?
I don't believe that calculation is fully
Residential.
met within the staff report, but there is no net gain between either of them. It is a simple swap between northern property lines and the southern.
My point is that it was stated that it was going to support 11 dwellings in 11.3 acres. My problem is if it's one dwelling per acre for part of it and one dwelling per 2.5 acres for part of it, if you just have one 2.5 acre dwelling, that leaves you with 9 acres. That means it should only be 10. If you have two 2.5 acre ones, it gets a lot less fast. And I'm just asking, where do we get 11 units when some of them have to be on 2.5 acres?
Mr. Lloyd.
Thank you. If I can break in here. What you were looking at was not a graphic that was supplied by staff. And so staff is not representing that there are 11 lots total. And so I agree with you. It does not look like it's an accurate representation of what will be there, but what I can say is that through future proposal, through a parcel map or a subdivision map, staff will ensure that there's adequate densities to support whatever is proposed. But I don't know that you're going to get a disagreement from staff in terms of that 11 unit count at this time.
So what's before us tonight is not an increase in density. It's a swap for designations.
That's exactly correct.
And we have heard from the applicant's representative to say that if that drawing that you submitted to us is inaccurate, that their intent is not to increase density. Mr. Edwards, anything?
No, it's a valid point that Commissioner Bruce has made as far as the graphic that was put up on the overhead. But you're not being asked to approve a development capacity of 11 units tonight. You're being asked to approve master plan and zoning swaps on 0.49 acres amongst these 3 properties. That's all you're being asked to approve. If you are to approve that, that doesn't mean that you're also approving or somehow blessing the ability of the applicant to put 11 units on there, especially now that this has been specifically flagged on the record. So I think that's covered. And I think that Mr. Lloyd is correct in pointing out this isn't part of the staff presentation. I don't think it's necessary to.
And it's not part of our decision.
No, you're not making that call tonight. And I don't think it's necessary to nail it down any further than that. The applicant, they know, and it may be that there was a mistake in someone's preparation of a map or something like that, but they're not here tonight asking for a subdivision, yeah, or anything like that. So I think you're fine to proceed however you want based on the evidence.
Thank you. Any other questions for staff or the applicant? Do we have any public comment on this item?
We do. Randy Bell.
Good evening, my name is Randy Bell. I think you've kind of addressed some of my concerns because it's pretty confusing what they're trying to do. And I would just ask the question, why? You know, are they gonna try to change the density because of this change? So I would consider that as you do it. I live in the area, I'm adjacent to this. The fire road goes through my property. There's an easement through my property. We've been there for almost 30 years, so just concerned about that and to get some clarification. Maybe we need that clarification before this is voted on, so thank you for your time.
Thank you. Is there any other public comment?
No further public comment.
Okay, I'll close public comment and bring it back to the board.
Madam Chair, I'm going to put this on the record briefly as well. A copy of that document, since it was not part of the agenda packet, is has just been presented to our clerks here at the dais, so it should be available to the public soon. if anybody wanted to view it, just to brush up on the details of that discussion that took place.
Thank you. Commissioner Haran?
I just want to be clear on, because the math is kind of confusing, that the amount of acreage that is in the current categories will be replicated when we switch whatever we're doing.
Staff, thank you.
Yes, so it will be replicated. It's a,
We're not going to have more of one zoning than another zoning than we have now.
correct. So it's a complete even swap.
Okay.
Both designations already exist. They're just
That's fine.
changing where they are.
Thank you.
So if we do the math, they're not going to get 11 parcels on that acreage. I want to be sure of that. I don't like that map that was presented with.
But I would just, I don't mean to interrupt, but I would remind our commissioners that that's not what is before us this evening.
Okay.
I can tell you again for the record that if you decide to approve the application tonight, you will not, by doing that, be approving their ability
increase in
to put
density.
11 lots on that parcel.
Can I provide some clarity, maybe?
Yes,
I'm just
Mr.
looking at
Lloyd.
a map. I'm looking at a map, and it looks like the map that we all looked at extends beyond the boundary of the 3 parcels that have been represented as part of the request tonight. And I think that's what we're seeing
This
with the
map.
additional lots. Yes, exactly. And hopefully that helps clarify things.
Yes, okay.
Madam Chair,
Commissioner Chesney,
I'd propose a motion.
recognizing we have 2 motions on this for master
Yes,
plan and
yes.
regulatory zone.
Yes, I do.
Thank you.
First would be the master plan amendment case number WMPA 18-0005. I move that after giving reasoned consideration to the information contained in the staff report and information received during the public hearing, the Washoe County Planning Commission adopt a resolution contained in Exhibit A of this staff report to amend the master plan as set forth in Master Plan Amendment Case WMPA 18-0005, having made the following 5 findings in accordance with Washoe County Code 110.820.15D. I further move to certify the resolution and the proposed master plan amendment in WMPA 18-0005 as set forth in this staff report for submission to the Washoe County Board of Commissioners, and authorize the chair to sign the resolution for the Planning Commission. In addition, the regulatory zone amendment for case WRZA 18-0005, I move that after giving reasoned consideration to the information contained in the staff report and information received during the public hearing, the Washoe County Planning Commission recommends adoption of the proposed regulatory zone amendment, having made all of the following findings in accordance with Washoe County Section 110.821.15. I further move to certify the resolution and the proposed regulatory zone amendments to WRZAA 18-005 as set forth in the staff report for submission to the Washoe County Board of County Commissioners, and authorize the chair to sign the resolution on behalf of the Planning Commission.
Is there a second?
Madam Chair, I second.
Is there discussion? Okay, so it's been moved by Commissioner Chesney and seconded by Commissioner Doncheck. Is there any discussion? Commissioner Haran.
I just want to make sure that, again, I stated a few minutes ago that on the record that we're not going to have any change in any of the acreage amounts that are in the different categories
Yes.
as part
So
of this.
noted.
So I will support it based on that.
Okay. Any other discussion? All those in favor? signify by saying
Aye.
Opposed? Motion carries unanimously. Thank you. Back to my agenda. We're now to item 9A for possible action and discussion and adoption. Mr. Lloyd.
Would you like me down at the podium? Would that be easier? I'll leave it
I
to the
think
chair.
you're fine there unless Mr. Edwards thinks you need to be at the podium.
Okay.
No, that's,
Okay, this is an item for possible action, discussion, and adoption pursuant to NRS 278.0502 of the proposed revised rules, policies, and procedures for the Planning Commission to clarify one, when, if ever, meetings may be canceled, when there are no substantive items of business to discuss or act upon, and two, if cancellations are to occur, which procedures must be followed. This is an item that was that came about from a request from Commissioner Bruce, from our last meeting, really resulting from a canceled meeting of June of this past year, 2018. In your staff report, staff has provided language from NRS as well as from code. And to paraphrase, the Planning Commission shall hold at least one regular meeting in each month, and that is found, that's the specific language of both code and NRS. Deputy District Attorney Edwards has weighed in on this matter and has opined that the intent of this law is to ensure that development items are heard and not delayed, and to ensure that the state mandated timeframes are adhered to. And I invite Mr. Edwards to weigh in if he so chooses. There is also consideration, if there are no business items to consider, there's a monetary as well as a time and energy expenditure to consider. And to, rather than holding meetings simply for the sake of holding meetings. So in your packet, staff has included essentially two options involving, or for your consideration. That first option is involves amending the rules, policies, and the RPPs that gives the chair the authority to cancel a meeting if there are not substantive items of business to discuss. The second option, and I provided basically two sets of draft RPPs. The second option involves amending the RPPs to memorialize the language of the state law and code requiring the Planning Commission to hold at least one meeting per month regardless of the circumstances. So hopefully you've had an opportunity to look at both drafts, and hopefully I can answer any questions that you have at this time.
This is probably a question for Mr. Edwards or Mr. Lloyd. Since this is a planning item, this goes through the same public hearing process, correct?
Is that for me or Nate?
No, I'll answer that. I'll take this
Thank you.
one.
I'm just asking for clarification because it says it's coming under as a planning item.
Right. So no, this is not what we would consider a public hearing.
Thank you.
So you don't have to follow the exact procedures for that. I do believe, if I can have 1 second, you are styled for action. It is a planning item, so there is public comment on it, but it's not regarded as a public hearing by the law.
Okay, thank you. Questions of staff, of commissioners of staff? Commissioner Bruce.
Well, to begin with, I requested a number of items be provided to the commissioners, and the only one that's close is effectively 2 copies of the rules, policies, and procedures. And I have others that I can show if the commissioners desire. I will observe that that Mr. Edwards did specifically say that there is no legal precedent on whether or not we can cancel the meeting. I will further point out that with Mr. Edwards' statement that NRS 0.025 parenthetical 1 parenthetical D defines shall to mean mandatory, and he puts in parentheses except as otherwise required by the context, is in fact an error. That is in Washoe County Ordinance number 110902.10 parenthetical I. What is in NRS 0.25 parenthetical 1 parenthetical D says, quote, shall, close quote, imposes a duty to act, period. Mr. Edwards talks about context and this and that and the other thing, and that it's not strictly interpreted. It has been my personal experience that attorneys before the act recommend that strict interpretation is to be observed unless you want to go to court. I don't want to go to court. I recommend strongly strict interpretation, and I have a third alternative to what the staff has proposed.
Commissioner Bruce,
Yes.
what we have before us is alternative A and alternative B. If we're looking at a third alternative, it would require tabling this item and not
That
taking.
would be fine.
But I would also note that what was requested of staff was an interpretation of the rules and regulations for governing this planning commission.
No, ma'am, it was not. That was
And-
not what was requested. That was not.
Commissioner Bruce, I
What was
respect
requested.
what you're asking for. Please allow me to continue. What is being heard before us this evening is that this, as I'm interpreting it, and as I have spoken with staff, we are not taking any action that has not been, this is not blazing new territory. It's not taking any different action than our Board of County Commission does, our Regional Planning Commission does, either of the city councils. A point of reference is that there was no business before the Regional Planning Commission, and that meeting was canceled for the month of August. The Board of County Commissioners regularly cancel meetings if there is no regular meeting scheduled. My concern is that if we hold a meeting simply to hold a meeting, we are fraught with error for government waste. Because if there is no planning item before us that would preclude a project moving forward, I accept the staff's report that we're not required to hold a meeting.
I vehemently disagree. I believe that we are required to hold a meeting, and I believe that the meeting can be rescheduled. It could be scheduled for later in the month. There are provisions in the rules, policies, and procedures presently for scheduling a second meeting the third Tuesday of the month on a regular basis going forward, should we choose to. My position is that a duty to act and to hold at least one meeting a month requires us to make every effort to do that and to take up planning items that maybe could be presented later in the month, but not the first Tuesday of the month, and be acted upon, such that we don't have meetings that are skipped, particularly when in the cancellation it was pointed out that the subsequent meeting was going to be really full the first of the month on the night before the National Independence holiday. I believe that the meeting could have been rescheduled, and at least some of it, including the first item tonight, since it was passed almost 2 weeks before the June meeting by the Board of County Commissioners, that could have been addressed, if no other, the third Tuesday of June. My recommendation is that we change the regular meetings, and I'm voicing this not as a motion, but
You're
as a
putting it in,
discussion.
I'm going to clarify for the record and ask Mr. Edwards to weigh in, is that you're providing comment to this agenda item.
Yes.
Mr. Edwards.
Wait, I'll comment on what? I didn't hear the rest of where this was going, so I don't know what the comment is on.
And that's the question I have, because what's before us is Exhibit A or Exhibit B.
That's all we can do.
And that we need to take action either one of those motions or table this item.
I suggest we table this item.
And I'm not in favor of tabling this item.
Do I have to make a motion to table this item?
Mr. Edwards?
Yeah, you can make a motion to continue it if you'd like. I'd like to put a couple things on the record regarding the legal analysis before you do that.
Please.
If the chair would allow that at this time. I wrote a rather extensive analysis on pages 2 and 3 of the staff report. That's in addition to quite a bit of other discussion and research that took place on this item in the run-up to its preparation and prior to tonight, between me and staff and dealing with the others in the DA's office as well in talking about this. I get almost a sense of like there's almost a personal tone to the way that the legal analysis was addressed earlier in the discussion tonight. And that's unfortunate because I'm not pro meeting cancellation or anti-meeting cancellation. I have never canceled a planning commission meeting. I don't have the power to cancel a planning commission meeting. I've simply been asked to provide an opinion about what the law means with respect to this issue. And that's what I've done, pages 2 and 3. I've been doing this for coming up not too far from now on 20 years. I've practiced with the county for almost 17 years. I've done the civil division stuff at the DA's office for about 8 years. I have quite a bit of experience dealing with these types of issues and these types of matters. I can tell you that the definition in the 0 chapter of the NRS that explains when shall is mandatory and when the context requires otherwise is a universally, almost universally followed precept of statutory interpretation, not only in Nevada, but throughout the entire country. In fact, you learned that all the way back in law school. Most people aren't aware of things like the 0 chapter of the NRS unless you're a lawyer, and that's kind of what we do. We're supposed to be aware of those types of things. The provision in the development code that was referred to earlier, it would be my opinion on that. That does not vary or divert from the NRS. It is built around those provisions of the NRS. And in my opinion, when you have provisions of the development code that are built around the NRS is the governing principle and statutory maxim for interpretation purposes. So I think that's valid. And my intent and my goal with the analysis that I wrote was to present to you 2 different ways of looking at the situation. And I did that. I provided 2 different manners of viewing this particular term and how it's interpreted, coupled with my experience about how this has been handled on the dozen or dozens of boards and public committees that I have represented over the years. So I intended to provide you that background and to allow you to factor that into your conclusion about what to do. You can pass a rule for your RPPs that says, as Mr. Lloyd indicated, that you're never canceling a meeting as long as you have, unless you have at least one a month. You can allow it to stand the way it is right now, which is the way it works in almost every public body that I've ever been assigned to represent. Or you can, you can pass a rule that deals with it in some other way, I suppose. But that's that's the additional comment that I wanted to put to the legal analysis that was done in this case. So there.
Thank you, Mr. Edwards. Before we take any motions, this is a public hearing item. Do we have any public comment on this?
We do not.
Thank you. So we'll close that and bring it back to the board to entertain motions. Commissioner Haran.
It's on.
It is on.
And with all due respect to Member Bruce, I believe that I would support and make a motion for motion A, I guess it's on there. And I think that I would just support that end of it. In all due respect to Mr. Bruce's feelings on it, I still think that we should, if we have no business, that we shouldn't hold a meeting. I think it's difficult to try and cobble together, well, this time we'll do it the second Tuesday or the third Tuesday. You know, we all have schedules. Staff has schedules. I think that, having a schedule is beneficial to doing business. So I would support and be willing to make a motion on A.
Other comments?
I'll second the motion.
Well, there hasn't been a motion.
Hasn't been a
I'm just
motion yet.
asking for
Make a
comments
motion.
right now. So, and I too, in complete respect of Commissioner Bruce, I completely respect your opinion and respect your right to express your opinion. But at the same time, as a member of this commission and having served on a number of public boards and advisory groups and such, I am extremely cognizant of encouraging community input, and changing meetings around would defer from that. So meeting on the second Tuesday and have a standing meeting, the public then knows when our meeting is. I'm also very cognizant of not wanting to waste taxpayer dollars by convening a meeting simply to convene a meeting. Other comments? Commissioner Lawson.
Thank you, Madam Chair. I was very concerned about the cancellation of the June meeting, particularly when we were faced with the agenda we were in July. Perhaps that's an anomaly. I trust that it is. I have concern about cancellation of meetings. Just simply put, I have concern about it. At the same time, and I respect Commissioners Bruce, I respect your concerns as well, sir. I'm not a lawyer. And as much as I've studied NRS and think I know what shall means or think I know something else, I've come to find out that's not necessarily the case. I don't like either of the options before us, quite honestly. I hate to moralize either, that we're giving the planning chair latitude to cancel a meeting, and I trust you, but I don't necessarily trust the next person that might sit in that chair. And so that gives me pause. At the same time, I have trouble with option B that says we won't ever do it, because then that limits our ability. I'm comfortable with taking no action. I think that the way it was handled in June was legal. I think it was probably appropriate. I don't like it, but I accept it. And I accept Counsel's interpretation of the legality of it. He certainly knows a hell of a lot more about it than I do. So I just wanted to express the same type of concern that Commissioner Bruce has with respect to cancellations. I'm willing to support any or no motions.
Okay. This is a question that I have for staff in terms of, in the entire staff report, it does say that the chair has that determination, but the chair does receive input from staff. It's not an arbitrary decision by the chair of the commission to cancel a meeting.
That's absolutely correct. However, I think it's written such that staff doesn't want to bear that responsibility.
So
in
it's a
terms-
staff and chair's
Exactly.
You're going to bear the burden.
for now. Commissioner Chesney, you look like you have a question.
Yeah, my issue with this is if we can cancel a meeting, then I think the chair should, and staff should have the responsibility and the ability to schedule 2 meetings in a month.
And we do have that ability. Our current rules.
Because the July schedule was ridiculous, absolutely ridiculous and uncalled for. And many times, we know in advance that some of these agenda items are very controversial, and there will be hours of public comment. And I believe when we know that, as soon as we get our packages and I read them, I can say, all right, this is gonna be a long, long night.
Pack your Wheaties.
And we should take a look at that in advance and say, hey, we're gonna cover this issue or these issues, a couple issues tonight, and then we're gonna schedule another meeting for later on in the month.
And I, after the July meeting, I did meet with planning staff, Mr. Lloyd and his supervisors and such, and had that very conversation to say, and it is being noted that this commission will likely expand on meetings.
Okay. But
But we do have that opportunity now.
But that is not what's in front of us tonight. That's.
No, it's just to revise our rules and regs for either Exhibit A or Exhibit B. Is there other questions before I entertain a motion? Commissioner Bruce.
I agree with you about scheduling a second meeting. If it were scheduled, then I would have no problem whatsoever canceling the first meeting and going to the second meeting. I further would have no problem whatsoever if the first meeting is short and the second meeting isn't going to need anything, that the commission canceling the second meeting. My problem is canceling the only meeting in the month. And I have tried to I've thought about recommending that we just schedule the second meeting. And I did not, because I don't think that we're going to have enough to really require that unless we want to go that way so that we can regularly schedule the second meeting. I did have a proposed amendment to the rules, policies, and procedures that I think addresses not canceling the meeting, but rescheduling it. It talks about, it says, should the first Tuesday of the month fall on a holiday or interfere with the special event using the meeting facilities of the county complex, the meeting shall be held on an alternate date and/or at an alternate meeting facility as determined by the chair or acting chair. That is already part of that.
Yeah, we do. But that's not the issue before us this evening. In terms of, this board would not schedule meetings on holidays, if I'm correct, Mr. Lloyd or Mr. Edwards?
Yes, that is correct. We do not schedule meetings on holidays.
And what's before us this evening is changes to the Planning Commission's rules, policies, and procedures. So.
And we only have 2 options.
So I'm back to asking for a motion. Commissioner Haran.
Madam Chair, I move to adopt the Planning Commission's revised rules, policies, and procedures as shown in Exhibit A.
Madam Chair, I second.
It's been moved by Commissioner Haran and seconded by Commissioner Doncheck. Is there any discussion on this item?
I think it's been a really healthy discussion. And, you know, one of the things that, and all the different boards and stuff I've served on, too much structure is not efficient. And I think that this allows us to do the business of the people on a timely and good use of time. I understand the issues about shall and so forth, and I think that I really want to support this. I think we should give it a go, and if we find we have a chairman that goes rogue on us, we can change it.
Other discussion? All those in favor signify by saying aye.
Aye.
Opposed?
No.
Motion carries 6-1. Thank you. We are now at item 10, Chair and Commission items, future agenda items. I will note for my fellow commissioners that after our July 3rd meeting, I did meet with, and this is after an item that was before the BCC, I met with Chair Burke-Bigler to begin the process of working on joint meetings or workshops with the Board of County Commission and the Planning Commission to improve communication. I've been asked by staff to ask for possible topics from each of you. That clearly, since this is just coming before you and we can take no action, but if you can be thinking about those items, I would appreciate feedback from you.
Would you like those by the next meeting?
Yes, please.
Okay.
And then Mr. Chesney's going to bring this up, but I have a question about containers. I thought this issue was resolved. So this is for a request for a future item.
Fair enough, yes.
Any other requests from commissioners for future agenda items or information
yeah,
from
I-
staff?
for-
Commissioner Chesney?
Yes.
I stole your thunder.
Well,
but-
yes, I just, hey, for Nate, I keep hearing different interpretation of what a taking is. When it comes to, if we make a decision, let's say Joe Blow's set up to build 10 commercial buildings on their property, and then all of a sudden they come in and they want to put in 250 residential units. And we go, well, wait a minute, that doesn't meet the character of the area, and blah, 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 blah. And somebody will say, well, that's a taking. Well, we need to know, is it a taking or not a taking?
So you're asking for clarification on what
Yeah, I
defines
guess
a
I
taking?
am, yeah.
Okay.
Yeah, and I certainly think there's a number of ways that could be handled. I could write up something in response to an email, if you could send me an email that just follows up with that, and then I could write you an analysis, try to capture the idea of what constitute takings in a nutshell. That's a big nutshell.
Yeah.
Because there's different kinds of takings. There's exactions where an approvement authority says, okay, we'll approve your project, but you have to donate X amount of land for this or that. Those are exaction type takings. There's regulatory type takings where someone alleges that the regulations are so onerous that they prevent any valid or any viable economic use of the property, and that's a taking. So those are sort of backdoor type takings. There are inverse condemnations where the government engages in some type of use of property that destroys the use of another person's property. That's a inverse taking or condemnation. And then there's the good old-fashioned variety, which is the condemnation where the government body says, we're taking that piece of property because we're going to put a freeway off-ramp over it. That's your classic condemnation, eminent domain type proceeding. And then there are physical occupation takings where, for example, the government allows a utility wire to run across someone's building or something like that without an easement being in existence or something, and they physically occupy the property. Whole huge swaths of info. So if you send me an email, I will get you a summary of that.
Okay, or if you can point us in the direction of where we can research it ourselves, I don't mind that.
Yeah, and the problem you'll run into with takings is that it's so wide open and so vast of an area of law that you'll get overwhelmed. So I'll do my best to give you kind of a summary of that if you just send me an email to follow up.
Thank you, Nate. And then, Trevor, for the record, on County Commission meeting October 11th, 2016, the County Commission specifically directed staff try to bring through the section on cargo containers. The County Commission turned it around, gave them specific orders on exactly what they wanted to see in that section. That was in October 2016. And I know I've heard, we're overworked and underpaid and the whole thing, but the fact of the matter is you were directed by the County Commission. And now we have code enforcement had code been rewritten with the direction of the county commission, we have people that are being tagged by code enforcement, and had that have been done in a timely manner, these code enforcement issues wouldn't be present today. So therefore, the dragging of the feet of going back and following the county commission's direction has put people at essentially financial peril. $100 a week or $100 a month, $100 a day.
No, Madam Chair, I need to jump in, this was brought up in public comment earlier in the meeting, but if you're gonna request a future agenda item, then that's fine. If you're gonna request for information from staff, that's fine. But it can't turn into a discussion about the issue.
We'll provide
I'd like to,
Yeah.
I need something back.
So that's why
We will
I've
provide
asked
an
for it
update.
as an agenda
Yes.
item to address all those concerns.
Absolutely.
Thank you, that's all I have.
Any other requests from staff? Commissioner Lawson.
Thank you, Madam Chair. I would request a staff presentation on the process for staff review of technical reports and included in applicant presentations for tentative maps. And I would be happy to work with Trevor specifically on what I'm looking for there. I want to know when an applicant makes a claim that a hydrological study has been done, or a geological survey has been done, or a traffic study has been done. I want to understand the process of how that's handled by county staff in making a recommendation for approval of a tentative map based on the science within those reports. And if there are opportunities to improve that process. But I think what I need to understand first is what that process looks like. Trevor, do you understand what I'm asking?
Yeah, I do understand very well.
Okay, thank you.
And then to, just to tag on to that, what I've also, when I met with planning staff, what I also asked for was to schedule workshops for this commission to work with planning staff to understand those types of things, is just to help us improve our ability to do our job.
Absolutely.
Other questions or other requests for information from staff? Seeing none, we'll move to item 11, Director and Legal Counsel updates, report on previous Planning Commission items.
Okay, the chair touched on the item that was heard by the county commission 2 weeks ago, and again, reiterating, the county commission asked for more communication with planning commission as well as Board of Adjustment, and so we're looking at, again, different topics of discussion for that meeting, but we would like to schedule that fairly soon. And secondly, there was an item, couple items that were heard by this body as well as the City of Reno Planning Commission, that joint meeting that was held coming on 2 months ago. That was taken to the joint county commission as well as city council. And two items. The first was the United Federal Credit Union request, master plan amendment, that was approved unanimously by the city council and county commission. And then the second item was the Echeverria, where county commission, also city council, agreed to remove it from the joint plan. So that did go through. And that's all I have.
Thank you. Legal information and updates, Mr. Edwards?
A few months ago, there was a subdivision out in the Lemon Valley area. There was a large amount of public comment that came in that night. One of the public commenters was Danny Cleus. He then filed an open meeting law complaint against the Planning Commission based on, I don't know if any of you remember, but there was a glitch with the timer on the public comment. He was given additional time to speak. I filed a response to that complaint at the request of the Attorney General's office because they have jurisdiction over open meeting law cases. And I just received the Attorney General's office's determination on that, and they found no violation by the Planning Commission. So I wanted to let you know about that. That's all.
Thank you. We're now to item 12, general public comment. Do we have any public comment?
We do. Catherine Snedeker, followed by Derek Perkins.
Thank you.
For the record, my name is Catherine Snedeker. I'm a non-person, non-resident, unenfranchised, natural woman, human being. By the way, a person is an entity. You're all persons. I'm not. I'm really tired of Washoe County and code enforcement coming out to Palomino Valley to issue zoning violations. We are not a residential area. You tricked us. This board tricked us, every one of you. And so did staff. We filed through the administrative process to change our zoning back to agriculture that was taken away from us, where containers wouldn't even be an issue. And what you did was you renamed us from general rural residential to general rural agricultural, with all the residential things remaining. What a fraud you are, every one of you. We worked for 3 years to get the zoning back that was taken away from us arbitrarily by staff. There were no administrative procedures followed telling what was going to happen on each step of the way. Bob Webb came out and announced it. We're changing your zoning from A7 to GR, but don't worry, nothing's going to change. And that was the end of it. Now we have residential regulations on us. You can do more things in Sun Valley than we can do. That's kind of stupid. We've got 40 acres, they got a little lot. I'm tired of you taking our property rights. We have no services, 0 services from Washoe County do we get when we pay our property taxes. They've taken away our volunteer firefighters. That's why you had over a 48,000 acre fire out there. Because we didn't have our volunteers that could have gone and put a good handle on it until an hour later when the paid guys get there, they could put it out. We have 0 services from this county, but we sure get a lot of harassment. And frankly, I'm sick of it. And I think you better change your ways. Y'all live in the city. You don't know what it's like living out in Palomino Valley. You don't have a clue. And you don't get to tell me how I'm gonna live based on your personal opinions and experiences. Thank you.
Thank you.
Derek Perkins.
For the record, I'm Derek Perkins, not an entity, living flesh and blood man. I'm not gonna sit here and kick a dead horse. You guys know how I feel. You guys don't live in Palomino Valley in the rural agricultural area. She's right. Our rights are being taken away. We're getting fined for trying to do better for our families, build ourselves alive. Why? I'm gonna request that you guys actually dig deep and think about it when you guys bring it up on the next agenda. 10+ acres, rural agricultural area, exempt from the codes and enforcements on the containers or whatever you're gonna fine us on. What's the point? I mean, I paid for the container, I paid for the taxes, paid for all my permits. Why kick me down more? I mean, trying to do the best for my family, working hard every day. Now I'm gonna get a $100 fine a day and get a lien on my property for storing my things? Just something to think about, and that's all I got. Thanks.
Thank you.
No further public comment.
Okay, thank you. Entertain a motion to adjourn.
I move to adjourn.
Thank
Second.
you.